Hello class, I am Ms. Leal and today I will be teaching you about competence to testify. So the purpose of this presentation is to give a general overview of competence to testify during trial. The key points that I will be going over within this presentation are the competence to testify in general, the processes of professionals involved, the legal standard, procedural issues, the disposition of a competent defendant, the competence to represent oneself, and the difference between competent versus incompetent witnesses. Competence refers to a defendant's capacity to function meaningfully and knowingly in a legal proceeding. Competence applies to every stage in the criminal justice process, but is most often raised in pretrial hearings. A defendant can be found competent and still plead not guilty by reason of insanity. So the questions are, why is it important to know the difference between competence to stand trial and competence to represent oneself? How can confusing both meanings affect an individual in court? Starting with competencies to testify in general, Rule 601 demonstrates that every person is competent to be a witness unless these rules provide otherwise. But in a civil case, state law governs the witness's competency regarding claim or defense for which state law supplies the rule of decision. Now, looking at the processes of professionals involved, Rule 605, judge competency as a witness, means a juror may not testify as a witness before the other jurors at trial. If a juror is called to testify, the court must give a party an opportunity to object outside the jury's presence. Rule 606, jurors' competency as a witness. Judges and jurors are incompetent as witnesses in the present case and in proceedings concerning prior cases in which they are participating. Within the legal standard, I will be talking about 4 different parts. The first being historic antecedents. This is the rule that an individual must be competent to undergo the criminal process, which originated from the common law. If an individual was mute of malice or mute by visitation of God, then courts seek to ascertain. Mute of malice forced courts to assign a heavier punishment, as opposed to those mute by visitation from God who were spared ordeal. The second point being mentioned is the competence standard. In Dusky versus United States, the United States Supreme Court set forth a definition of competent to stand trial. Now, that hasn't come to be the standard for all criminal proceedings in federal court and in most states. After a competent examination is ordered by a judge, a psychologist or psychiatrist typically conducts the evaluation. The Supreme Court definition of competent to stand trial states that the test must be whether the defendant has sufficient present ability to consult with his attorney with a reasonable degree of rational proceedings against them. So we are looking at their ability, their capacity, their understanding, and whether there's any mental illness or intellectual disability. Although I only mentioned 4 components, there are many more relevant items that you can add under. So looking at number 3, the amnestic defendant. This type of defendant forgets or fails to remember what their actions took place and then seen as incompetent. In other cases, the individuals who have amnesia pose a threat to an accurate adjudication. And lastly, we have medication-induced competence. This refers to individuals who are suffering from psychosis and are then administered with psychotropic medication. However, there is a big controversy with using drug-induced competence in trial. Using these types of medication can cause side effects, which can diminish a defendant's ability to understand and participate in their trial. Now, our next topic is procedural issues. When issues arise, there is a request for a competence to proceed evaluation, which may occur at any point in criminal proceedings. Some of the things we may ask ourselves are, who may raise the issue? What are the standards, recommendations for granting an evaluation? What is the reason why which the evaluation is being sought? What is the competence examination setting and length and the adjudication of competence? Now, the disposition of incompetent defendants is the stated purpose of treating a defendant found incompetent to proceed is to restore competence that the adjudication process may resume. Looking at trying incompetent defendants, trying and punishing an incompetent individual means denying the right to due process. This video is a perfect example of that.
Jackson v. Indiana, 1972. In 1968, Theon Jackson was charged with 2 separate robberies. Jackson was found incompetent to stand trial because he was an illiterate deaf mute with an extremely low IQ level. Because he was not competent to stand trial, Jackson was committed to a psychiatric hospital for treatment until he was deemed sane. Doctors doubted that Jackson would ever be competent to stand trial, so essentially, he was committed to an institution for life. Jackson's attorney appealed his confinement all the way to the U.S. Supreme Court. In a 7-0 decision, the Supreme Court ruled that the actions by the state of Indiana were unconstitutional. The court ruled that a person could not be committed for an indefinite period of time until he was competent to stand trial. This was ruled a violation of both the Due Process Clause and the Equal Protection Clause of the 14th Amendment.
So now looking at mental conditions, some of these mental conditions can be psychotic disorders, intellectual disability, mental retardation, personality disorder, and amnesia. So the conditions can have an effect on how trials may proceed. Looking at inappropriate hospitalization, there have been many states that have failed to impose timeframe limitations on how long defendants may be involuntarily hospitalized. Some states have also showed no concern for where these treatments have taken place. About 35 states have specific statutes concerning outpatient restoration, and only 16 have a functioning outpatient program. For example, the Outpatient Competence Restoration, or OCR, is a function of United States law that provides outpatient competency education to non-dangerous defendants who are found incompetent to stand trial. Then there's incompetent defendants' rights to refuse medication. Within the Book of Milton, we have learned that treatment designed to restore competency can be denied by the defendants. There are many reasons for this. However, some individuals who have severe mental disorders like schizophrenia lack insight into their own conditions, so they can't recognize how ill and symptomatic they are. Despite this latter concern, most 20th century lower courts concluded that defendants found incompetent to stand trial may not refuse medication that is likely to restore competence, primarily on the ground that the state has a strong interest in trying persons charged with crimes.
Jackson v. Indiana, 1970.
Now, so competence to represent oneself. Here, we'll talk about the number of studies that have examined the characteristics of defendants who have been adjudicated incompetent to stand trial. The variance in the proportion of cases resulting in an incompetent finding may attribute to a number of factors like the characteristics of an incompetent defendant and the quality of competence evaluation. In 1975, Brenda versus California, the U.S. Supreme Court stated that the Sixth Amendment guarantees a criminal defendant the right to assistance of counsel. However, defendants may represent themselves to a pro se defense. Even though we are given the opportunity to represent ourselves, it is important to know the difference between competency to stand trial and competency for self-representation. So this video will help give us a visual.
In Ferretta versus California, the United States Supreme Court held that a criminal defendant has a right to waive his Sixth Amendment right to counsel and defend himself at trial. But what if the defendant is so mentally ill that despite being mentally competent to stand trial, he lacks the capacity to represent himself at trial? Does Ferretta still require a trial court to allow such a defendant to represent himself? The court addressed this issue in Indiana versus Edwards. Ahmad Edwards attempted to shoplift shoes. After the store's security officer confronted him, Edwards fired a pistol, wounding a bystander. Edwards was charged with theft, attempted murder, recklessness, and battery. Because he was indigent, the trial court appointed Edwards an attorney. After a psychiatric evaluation concluded that Edwards was schizophrenic and delusional, The court found that Edwards was incompetent to stand trial under the standards set forth in Dusky versus United States. The court then committed Edwards to a state psychiatric hospital for treatment. After a lengthy period of treatment, the court found that Edwards had regained his competency. At his jury trial, Edwards asked to represent himself, but the court denied the request. Edwards' court-appointed counsel represented him at the trial. The jury convicted Edwards of criminal recklessness and theft, but couldn't reach a verdict on the attempted murder and battery charges. At his retrial on the latter two charges, Edwards again asked to represent himself. Citing the psychiatric reports, the court found that Edwards suffered from severe schizophrenia and concluded that, although Edwards was competent to stand trial under Dusky, he wasn't competent to defend himself at trial pursuant to Ferretta. The court thus denied Edwards' request. Edwards was represented by appointed counsel at his retrial. The second jury convicted Edwards of attempted murder and battery. On appeal, the Indiana Court of Appeals reversed Edwards' convictions, concluding that the trial court had violated Ferretta by not allowing Edwards to represent himself. On further appeal to the Indiana Supreme Court, that court affirmed the Court of Appeals. The state of Indiana successfully petitioned the United States Supreme Court to review Edwards' case.
So now looking at competent versus incompetent witnesses. A competent witness must demonstrate personal knowledge, so Rule 602, meaning the witness had to be present at and observed all events they are testifying about. If the witness is testifying against an event where they saw someone else do it, then there needs to be a foundation laid out to support their testimony. Now, if the witness is presenting or testifying against their own actions, then there is no need for a foundation. There are ways to tell if a witness is incompetent, whether they may be intoxicated at the time of the event or trial, or they violated a separation order, or are in violation of discovery rules. The list goes on, and the court can also disqualify a witness if they are incapable of expressing himself or herself concerning the matter as to be understood, either directly or through interpretation by one who can understand him or her, or incapable of understanding the duty of a witness to tell the truth. I have linked all my resources, and this was my presentation on competence to testify. Thank you for watching.